us that he subpoenaed documents
So I
for.
got a letter here from her saying that information request is not accessible to me, as it is contained on our servers, which information economic director Don Bell is in charge of.
Right, but then Don Bell can testify and tell you all about that, Judge. Go ahead.
And Your Honor, just to be clear, the documents that were produced in response to the grand jury, and the grand jury's opinion, did not come from me, and I did not withhold a single document, even though he has stated in court proceedings that I wrongfully did that. And he said that I did that.
Your Honor.
And so the fact is
All right.
that he asked to speak to my client, Karen Phillips, without me being present, and he did so, correct?
Karen Phillips is not represented by Mr. Stutes, first of all.
But I
Mr.
was at the
Stutes-
time.
Mr. Stutes, Terry Phillips, sorry, Mr. Stutes, Philip Smith, and Thomas Wilson were all involved.
This is
All
interesting
highly
history,
involved.
but it's not happening one bit.
But the point is that he says we can't trust us. And so that's why I'm responding to that. He says
We're
we
going
are
to be
not
operating under
trustworthy.
a court order now. And all I need is to get you all at least to attempt to identify some relevant information in these emails so that we can narrow this down. I know that we don't need 150,000 emails. We've got the attorney-client down to 19 now, at least on those matters. And so, no, there's no reason to get personal health information and that sort of thing. It's not relevant, period. And even if it were, we might have a big issue, but it's not.
I think that the one thing the bigger point I wanted to make was that by me seeing these emails and having these emails, there's no waiver of any privilege. I'm the district attorney pro tem for Smith County.
I'm sorry,
There's no waiver of any privilege by letting me see these emails. I'm the district attorney pro tem for Smith County. So whatever they're seeing and whatever when they're doing their review and their
it's
facility.
not going to be a waiver because it's going to be a court order.
Yeah, but I guess in terms of trying to narrow the scope, unfortunately, I don't think there's an easy way to do it other than having someone just look through every single email.
Well, that's not going to happen. Nobody is going to look at 150,000. I mean, that's just an impossible task. And so we're going to have to figure out something better than that. And so something better than that is going to be, and I'm asking you to have your input and say, okay, here are the things that I want to search. These are the labels, these are the identification issues that we want to put in, more than just the name of the contract and the name of the company. And see where that gets us, and see if we can omit these emails that are just personal emails that don't have anything to do with this case or if it's going to help us if you get them.
One thing that, I don't know if this will help or not, is from the original grand jury request, I'm sure there was a set of emails that somebody, I don't think it was Karen Phillips, but she had nothing to do with this, but somebody specifically held onto those emails saying they're privileged, I'm not gonna turn those over to me. If those emails still exist somewhere, then those are ones that we should get, or at least let you look at. You know, I don't know if they still exist.
I'm going to look at these 19 for sure.
Sure, I guess there might have been an original subset in the original grand jury request that they didn't turn over to me.
Well, I'm sorry you have all this history to deal with, because right now, what I'm trying to do is just handle the issue before me. And right now, what we want to do is produce the relevant emails, the things that might be of some value in this prosecution of this case, but exclude things that are absolutely irrelevant and have no bearing on it and no business being, exposed. So I'm pretty sure if y'all put your mind to it, you can sit down and list a set of identifiers that will, people do this all the time in production and in discovery in civil cases. And it's kind of new in criminal law, but in civil cases, they do this all the time with, the old asbestos cases and all that stuff. That's the way that works. And there's a way of doing it, and it will work. You just, have to work at it. You have to cooperate. And that's what I'm asking you all to do is sit down and come up with a list of, this case better than I do. A lot better. I'll probably get to know it better as we go along. I found that out with the last case I was down here. But you all know it a lot better, and you will be able to come up with the names and identification. In fact, that was one of the questions I
Judge, we're happy to do that. I mean, all we've asked for is to have the court order and narrow this down and have the benefit of the court looking at it in camera. We're happy to work with him. Back even before, if he'd come to us and said on the executive session.
Let's don't go before.
So
I mean,
we're happy
history
to.
is
We're
over.
happy to.
And let's go forward from here.
That's all we're asking.
And, I'm gonna let y'all meet. I don't know where there is a good place to meet here.
Judge, we can find one of the empty jury rooms. He's welcome to come up to our office, whatever works.
All right.
Your Honor, this is something that's gonna take time for me to compile a list. I don't think that it's appropriate for anyone in the DA's office to be handling this. Ron Stoops, if he's hired by the county to deal with this, I think Thomas Wilson, Phillips, some of the witnesses in this case. So like, I don't know if they should be handling any emails, like doing any emails. We can do this with Ron Stoops. The things I need to create a long list. I'd like to have Don Bell, who's the IT person, present, so we can do this together. I don't want to do it on the phone.
No,
Like,
you know, I want you to do it while you're here.
You know, so I'd like to be able to, I'm not to, so I have a program on my computer that allows me to look through these emails very easily. So I'd like to, probably have to go, come back in, in a week, or come back whenever it's convenient to do this, so I have my search terms based on this evaluation of that computer system.
Can I add one thing, Judge? If he wants to call Mr. Wilson and them as witnesses and the court finds that that's allowed, so be it. There's nothing that prohibits a witness from helping the prosecution get meaningful documents. These are individuals that know more about this stuff probably than any of us do. So, I mean, all we're trying to do is, I mean, really, we would be glad to step out of this. I can't tell the court how much I'd be glad to step out of this. Unfortunately, Article 44 of the Government Code says I can't. But we are happy to work with Mr. Brody, the AG's office, but if we're going to do it meaningfully, it'd be great to have those individuals present. If he wants to call them as witnesses, that'll be a big issue for court. But having Don Bell there, Mr. Stoots, and the problem is that when just one thing, Judge, when he says, I'm the attorney pro tem over all this, it's a circular argument. I got off this because I can't be the article, the section 44 attorney and investigate them.
Well,
And that's what he's saying he wants to be. So we are happy to stay on this and work with, in conjunction with Mr. Stoops and the AG's office, have my lawyers present, and try to give him the information he wants while protecting everybody involved. And that's so we'd like to have that.
Well, let's give it a try.
We're happy
Let's
to.
give it a try today.
Okay.
And then, Mr. Brody, if you feel like you still need some hearing, or some additional, motion, of course, we can work toward that. But I'd sure like today to get a list and, see if we can't get, this narrowed down to more relevant information and, have this behind us. Because we've got to get this done before we can really move on with this case. This case is, kind of depends on all this stuff.
We're
And the
happy.
state has a duty to produce it, so, I mean,
We're glad to. If we can, we just want to
public
protect those
information,
things.
basically, other than the fact that some of it may be privileged and
And that's
we'll
where
take
it
those
is.
up individually.
Yeah.
But I have a feeling the vast majority of it's not gonna be something for me.
If it wasn't for HIPAA and all those other things, we probably wouldn't even be here. And so,
There's always something.
there's always something, and we're glad to work with the court and get it done. So,
Your Honor, I guess, when they first submitted their non-party motion, they provided you some emails, I think, were from ATS to the county. I think there should have been something, they wrote in the letter that they submitted to you that they provided you with some sort of thumb drive of this with those emails. I think those emails we should give them to as well.
I'm not sure what you're talking about.
They were presented to the district clerk's office, Your
The
Honor.
what?
They were presented to the district clerk's office. They should have-
Oh, these are not, y'all are not asserting a privilege.
Those we've turned over to the court as
I
the order.
actually needed to ask you what all this was. I think these are just the subpoenas themselves, which really don't need to be
And we also have
And then there is this document that has, from, the state, thumb driving, containing all emails, except the ones that are certified.
correct. So those were the ones I think that, when we talk about the state of Smith County DA should be able to provide to me as Smith County DA pro tem. Because those
Well,
are not
I
privileged.
mean, they're not asserting a privilege to these.